I'm here today to announce a lawsuit filed by the state of Texas against the United States of America, the Secretary of the Department of Homeland Security, the Commissioner of U.S. Customs and Border Protection, the Deputy Chief of U.S. Border Patrol, U.S. Customs and Border Protection, the Acting Director of U.S. Immigration and Customs Enforcement, and the Director of U.S. Citizenship and Immigration Services. There are a total of 17 states that are plaintiffs to this lawsuit. Texas is joined in this lawsuit through state attorneys general by the states of Alabama, Georgia, Indiana, Kansas, Louisiana, Montana, Nebraska, South Carolina, South Dakota, Utah, West Virginia, and Wisconsin. Also through governors, Governor Bryant of Mississippi, Governor LePage of Maine, and through both the Attorney General and the Governor, Idaho, and then also through Governor McCrory of North Carolina. Now, two things are clear. Our immigration system is broken and it must be fixed. Second, the Constitution prescribes immigration policy be fixed by Congress, not by presidential fiat. The President's executive order and the actions of federal agencies to implement that executive order directly violate a fundamental promise to the American people. Article 2, Section 3 of the United States Constitution says, the President shall take care that the laws be faithfully executed. This isn't loose language intended to embroidery the Constitution. The ability of the President to dispense with laws was specifically considered and unanimously rejected at the Constitutional Convention. To ensure the President was required to execute the laws passed by Congress rather than suspend them, the Take Care Clause was added to the United States Constitution. Supreme Court decisions make clear that the Take Care Clause does not give the President the power to dispense with those laws. Well, despite the clarity of the Constitution and despite Supreme Court precedent, on November 20th, 2014, the President announced that he would unilaterally suspend significant parts of the U.S. immigration laws. After he did so, the President candidly admitted, and I quote, "I just took action to change the law," end quote. Article 2, Section 3 was added to the Constitution to prevent this very type of conduct by a president. The President's job is to execute the laws, not de facto make law by suspending parts of laws that are passed by Congress. Our case will be proven in part by the words of the President himself and by those who work for him. Barack Obama himself said more than 20 times that he would be ignoring the law if he acted unilaterally to grant dispensation from the immigration laws. Among those 20 statements, I want to recount 4 of them for you. On March 28th of 2011, the President said, quote, "With respect to the notion that I can just suspend deportations through executive order, that's just not the case, because there are laws on the books that Congress has passed." Then, on January 30th of 2013, he said, quote, "If this was an issue that I could do unilaterally, I would have done so a long time ago. The way our system works is Congress has to pass legislation. I then get an opportunity to sign and implement it. Then fast forward to 1 year before he issued his executive order, on November 25th, 2013. He said, and I quote, "If in fact I could solve all these problems without passing laws in Congress, then I would do so. But we're a nation of laws." And then, just more than 3 months before he issued his executive order, on August 6, 2014, the President said, and I quote, "What I've said in the past remains true, which is until Congress passes a new law, then I am constrained in terms of what I am able to do. And I cannot ignore immigration laws any more than I could ignore any of the other laws on the books." Then just more than 3 months later, the President's next pronouncement on the issue was his executive order, after which he said, "I just took action to change the law." Our lawsuit shows that the President's executive order and the orders issued by federal agencies that serve under the President violate Article 2, Section 3 of the Constitution. Now, the President's defense is that he's using prosecutorial discretion, and that defense misses the mark. Prosecutorial discretion means not prosecuting someone for wrongdoing. It doesn't mean providing benefits to those accused of wrongdoing. The Department of Homeland Security sets out a series of explicit criteria for who will be eligible for the President's new immigration program. That's not prosecutorial discretion. That is a rewriting of the law that Congress wrote. Even the Office of Legal Counsel, in a memo dated the day before the President's executive order, dated November 19, 2014, points out 3 important differences between prosecutorial discretion and the program constructed by the President. 1, the President's deferred action is not merely a decision not to prosecute an individual for past unlawful conduct. Instead, it's a decision to openly tolerate an undocumented alien's continued presence in the United States. 2nd, deferred action carries legal benefits beyond non-enforcement, such as the right to seek employment authorization. And 3rd, class-based deferred action programs like the President's don't apply prosecutorial discretion on a case-by-case basis, but instead set forth certain threshold eligibility criteria and then invite individuals who satisfy these criteria to apply for deferred action status. These 3 things violate Supreme Court standards. In addition to violating the Take Care Clause, Barack Obama's executive order violates the Administrative Procedure Act. Agency guidelines like those issued by the Department of Homeland Security must go through what's called the notice and comment rulemaking process. That gives everyone in the United States of America the opportunity to weigh in on whether or not these rules and the processes are valid or should be contested. The Department of Homeland Security issued its guidelines without the required notice and comment period. As a result, they are unlawful. Now, Texas is uniquely qualified to challenge the President's executive order. The President's prior executive order on deferred action for childhood arrivals, known as DACA, had very real consequences in Texas. The state of Texas, our agencies, our taxpayers, and our people have sustained millions of dollars in costs to our schools, law enforcement, health care, and other things stemming from the President's 2012 DACA. The defendants we are suing in this case have conceded that the 2012 DACA and the federal government's failure to enforce the federal immigration laws has increased the flow of illegal immigration across the Texas-Mexico border, and that further failure to enforce the laws will only make matters worse. Well, Texas and the other states who've joined with us are asking for declaratory judgment and injunctive relief. Basically, we are asking for the court to require the President to go through the prescribed constitutional process of enforcing laws passed by Congress rather than making them up himself. I'll be happy to take a few questions.
Why is Texas taking a lead on this?
Texas has been at the epicenter of the results of the President's executive action. We saw that in the aftermath of the 2012 DACA. Texas faced the heaviest financial burden and consequences that were admittedly the result of the President's DACA. And as the defendants have acknowledged themselves, Texas will also suffer as a consequence of this most recent presidential order.
What's the difference between what Ronald Reagan did in the 80s and Herbert Walker Bush did with this executive action?
There are two differences. One, there was never any legal action that determined the legal validity of what Presidents Bush and what President Reagan did. But second, and more important, is that what President Bush and what President Reagan did was an effort to fulfill legislation that was passed by Congress. In this instance, the President of the United States, President Obama, has said he is taking this action because Congress will not act. The President's own words show that he's violating the Take Care Clause because he himself is saying that he's not trying to fulfill the will of Congress. Instead, he's trying to enact laws himself because Congress will not act. The President does not have that authority. Presidents Reagan and Presidents Bush never said that.
You're saying that basically Texas has future damages because of the presidential order does. That's what gives Texas standing, might cause an immigration flow?
The defendants that I named early on, various of them have already acknowledged that the President's 2012 DACA was a proximate cause of the challenges that Texas faced on the border last summer. They have also acknowledged that this additional presidential order is far larger than the 2012 DACA and could lead to far greater consequences for Texas.
Is there any kind of shaky legal ground in terms of proving something that might happen in the future because of the order?
If you look at the Supreme Court decision of Massachusetts versus the EPA, the Supreme Court granted standing to Massachusetts in a doctrine called parens patriae. Under damages the people of Massachusetts may suffer because of global warming. I will submit to you that the position Texas is in for standing purposes is far stronger than what the United States Supreme Court granted to Massachusetts in the Massachusetts versus EPA case.
Last question, please. Last question.
Are you suing to recoup any of the costs accumulated by Texas, or will that happen in the second round?
In this lawsuit, joined by all these states, and if I could give you a side comment here, the states that are named in this lawsuit are the states that we've had an opportunity to definitively communicate with at this time. When this lawsuit is all said and done, there may be more states than what are identified on the lawsuit right now. Remember this point, and that is when Texas joined in with other states to file the lawsuit challenging Obamacare, there were originally just 13 states bringing that lawsuit. It ended up in 26 or 27 states, so we may have more. But second, to answer your question, which I've now forgot, Tim. Money, yeah. In this lawsuit, joined together with these other states, we are not asking for money damages. We are asking solely for injunctive relief and declaratory relief, asking a court to declare that the executive order issued by the President, as well as the orders issued by the federal agencies to fulfill the President's executive order, are illegal. Thank you all very much.